in a concurring opinion in a federal court case addressing religious freedom. It was stated, "The greed and callous disregard for the property, history, and culture of others cannot be countenanced by the world community, nor should it be sanctioned by the courts." There's a long history in the U.S. of having a disregard for the history, religion, property, and culture of Native Americans. Their religious practices have been ignored and negatively impacted by government actions. Their cultural properties confiscated and sacred sites destroyed or abused. The federal government has created policies of removal and assimilation. But there are a handful of laws that do consider Native American heritage, and a few that were created to address it specifically. In this section, you're going to learn just a few of those laws. Federal Indian law is an incredibly complex and delicate web, and preservation issues relating to the protection of tribal cultural resources have to be considered in the context of issues of sovereignty, federal trust relationships, land rights issues, issues of reserved rights, tribal laws, international laws, because Indian nations are sovereign nations, and that's just to consider a few. This is the type of subject you could study for a lifetime, so in one class we aren't even going to be able to scratch the surface. This module, however, will attempt to address the issues that are most likely to come across your desk. You'll learn about the context of the creation and application of preservation laws, the American Indian Religious Freedom Act, a few executive orders, how ARPA and the National Historic Preservation Act are specifically applied in cases dealing with Native American cultural and historic resources, and the Native American Graves Protection and Repatriation Act. In order to set the stage, you need some context for understanding these laws. Before you consider heritage-specific laws, in fact, before you consider laws at all, you need to understand the context in which these laws are written, interpreted, and enforced. Laws impacting Native Americans are created and enforced in a context where misrepresentation and misunderstanding of culture impacts the law, and where other priorities may need to take precedent over cultural resources protection. Further, the interpretation of the law is complicated by the fact that federal Indian law is so incredibly intricate that its application is very often filled with mistakes and oversights. First, let's think about the concept of misrepresentation. Unfortunately, you see these types of stories in the news all the time, what may be classified as misrepresentation or misappropriation. Stereotypes of Native Americans are perpetuated by Hollywood and the media. Rooney Mara playing Tiger Lily, Michelle Williams in what's referred to as Red Face, Gwen Stefani, Johnny Depp, even Victoria's Secret fashion shows referring to a Thanksgiving theme. From Pharrell apologizing for wearing a Plains Indian headdress on the cover of Elle magazine, to a Kardashian in another magazine and on social media. Even Harry Potter author J.K. Rowling was accused of appropriating the living tradition of a marginalized people by writing about a Navajo legend in a story she posted as part of a 4-part series called The History of Magic in North America on her Pottermore website. This idea of misrepresentation, however, is not even remotely new. You've probably seen the photographs of Edward Curtis. These so-called iconic images are often seen in coffee table books and on posters. They're very stereotypical images. Curtis traveled around the country taking these photographs during the early 1900s. He was convinced at the time that Native Americans were about to disappear forever, so he took it upon himself to photograph as much of what he referred to as the vanishing race as he could. He created a massive body of work, but he definitely had an idea of what he thought real Indians looked like. Curtis was the original Photoshopper. It came to light later that he had staged the images to erase all signs of modernity, providing costumes for his subjects and trying to make Native people fit his notion of Indianness. A similar notion of this idea has been referred to by academics as the concept of the noble savage, or romantic primitivism, which persists today. It's the idea of a quaint group of people with a simple, albeit strong connection to the land and animals. During the 1960s and 70s, there were a series of ads with a character frequently referred to as the Crying Indian that ran as part of the Keep America Beautiful campaign.
Some people have a deep, abiding respect for the natural beauty that was once this country. And some people don't. People start pollution. People can stop it. Write for Pollution Booklet, Box 1771, Radio City Station, New York.
First of all, it is specifically troubling that the actor, who called himself Iron Eyes Cody, was actually a Sicilian American and not Native American. More broadly, however, the campaign perpetuated the idea that all Native Americans act a certain way, dress a certain way, and have the same beliefs and concerns. It ignores the fact that these are modern societies the same as any other. They have economic development and natural resource exploitation issues just like any other country, and that all tribes have their own identities, customs, practices, and resources to contend with. You're also likely familiar with the Washington Redskins controversy, another idea of misappropriation and misrepresentation. In 2014, there was actually an ad created by the National Congress of American Indians, created around the time of the Super Bowl. At a cost of $4 million for a 30-second slot to advertise, the organization wasn't able to afford the airtime, but the ad addresses the concepts of misappropriation and misunderstanding.
Proud, forgotten, Indian, Navajo, Blackfoot, Inuit, and Sioux, survivor, spiritualist, patriot, Sitting Bull, Hiawatha, and Jim Thorpe, mother, father, son, daughter, chief, Apache, Pueblo, Choctaw, Chippewa, and Crow, underserved, struggling, resilient. Squanto, Red Cloud, Tecumseh, and Crazy Horse. Rancher, teacher, doctor, soldier. Seminole, Seneca, Mohawk, and Creek. Mills, Will Rogers, Geronimo. Unyielding, strong, indomitable. Native Americans call themselves many things. The one thing they don't.
Misrepresentation is tied in with the next aspect, misunderstanding. For example, the lack of cultural understanding of land-based religions has proved problematic in courts' interpretations of the Constitution in this context, and in terms of what has and has not been saved. Land-based religions, which are often outside the scope of Judeo-Christian understanding, are insufficiently considered when addressing sites like Devil's Tower. This is a sacred site. It's essentially a cathedral. It would not occur to most people to climb the facade of the National Cathedral, but hundreds of people climb Devil's Tower every year. Or consider the San Francisco Peaks. These 12,000-foot volcanic peaks rise out of the Colorado Plateau, south of the Grand Canyon and north of Flagstaff. Environmentally speaking, the peaks are home to over 200 species of mammals and birds. Some species that live in the peaks are endangered, and it's also the only place in Arizona with alpine tundras and is one of the last remaining old-growth forests in the area. It's an ecological marvel, a comparatively lush ecosystem and aquifer in the middle of the desert. Culturally speaking, the peaks are sacred to 13 tribes, including the Navajo, Apache, Havasupai, Hopi, and Zuni. For the Navajo, the peaks are the sacred mountain of the West. It's one of the cardinal points of the Navajo universe. It's the northern cardinal point to the Apache. It's culturally significant and sacred to the Havasupai as the Great Snowy Mountain. To the Hopi, it's where the Kachinas, a group of gods, reside for half the year. However, it's the U.S. Forest Service, not any of these tribes, that determines what activities can take place on the peaks. The peaks have been determined to be eligible for inclusion on the National Register of Historic Places, and are even listed as a standard for a traditional cultural property in the National Park Service, Bulletin 38. The major issue of contention has been the use of reclaimed wastewater to produce snow at a resort called the Arizona Snow Bowl. Reclaimed wastewater is, of course, treated sewage. There's been a ski lodge on the peaks since the 1930s, which has been controlled by outside companies since 1979. As the ski resort became larger and the amount of snow on the mountain decreased, the need for man-made snow became an issue. Multiple lawsuits have been filed to prevent the use of the reclaimed water, but one of the underlying problems is the lack of understanding of what a sacred site is. Remember, the peaks are the sacred equivalent of a cathedral or a temple, and there are numerous newsreels where you can see protesters saying as much. Despite protests and legal battles, the use of reclaimed water was approved, and on the first day of testing the system, there was yellow snow. These are fascinating cases that you should spend more time on, and you'll have the opportunity to learn more about them in the assignment that accompanies this module. In addition to problems with sacred sites, there's also a problem with sacred objects, which you'll learn more about in a bit. And priorities also limit the attention spent on heritage resources. Always remember that preservation is always a balancing act. We balance preservation interests with things like health issues, environmental issues, economic issues, and the like. Sometimes preservation has to take a back seat. For example, poverty plays a substantial role in determining where resources are directed. Money always plays a role in what gets saved and what doesn't, and poverty can be a substantial problem on Indian reservations. Consider, for example, the Pine Ridge Reservation in South Dakota, the second largest Native American reservation in the United States, and also the poorest. With this being the situation, preservation wouldn't necessarily rank high on the list of priorities, but there's still a Sioux Preservation Office that handles these issues. Despite the massive amount of land taken from them, American Indian tribes are still the largest landholders in the United States, in aggregate nearly 100 million acres, an area just smaller than California. And much of this land is rich in natural resources. There's timber, grazing, croplands, oil, coal, and uranium. Sometimes people mistakenly assume that having these assets should equal prosperity. There's an accusation that there's some sort of intentional or purposeful neglect or mismanagement of these lands. But it's the federal government that plays a large role in managing natural resources on Indian lands. The BIA, for example, is who's responsible for leasing mineral rights beneath reservation lands. The natural resource exploitation of these lands is conducted in such a way that has led to some of the worst environmental degradation in the country, and these sites are often the last to be cleaned up. It's a significant environmental justice issue. What does this translate into for preserving cultural resources? Well, there's the obvious implication that when you're just trying to get by, you aren't particularly interested in whether Section 106 process was followed through in the most advantageous way for you. Or if you're concerned that your drinking water has been contaminated by uranium or will be contaminated by a pipeline spill, you have other interests. Also, if a nation doesn't have the money to pursue a claim or the money to acquire property that was likely taken from them illegally in the first place, then they can face sometimes insurmountable hurdles. This is in no way to suggest that tribal preservation isn't done and done well. It's just to say that there are complications associated with these resources that don't necessarily exist off-reservation. Finally, complexity is an issue. Felix Cohen wrote the Handbook of Federal Indian Law. Cohen's book, which was actually first published during the FDR administration with subsequent revised editions, is the authority on this subject. Cohen said that there are few subjects in the history and law of the United States on which public views are more dramatically and flagrantly erroneous than on the subject of Indian affairs. There are over 4,000 treaties and statutes dealing with Native Americans. Regulations and guidelines addressing the same are even more numerous. Then there are the tribe's own laws and some state laws that add to how complex the issues are. Throw on top of that the international implications because these are sovereign nations, and it gets incredibly confusing. There are 4 considerations with all matters of Indian law that you always have to keep in mind when you're working through any type of legal problem: sovereignty, the federal trust responsibility, reserved rights, and federal recognition. Native American nations are sovereign nations. They are their own political entities, distinct political communities. This independence, however, is subject to Congress and its ability to regulate and change the status of tribes. In fact, Native American governments generally only deal with the federal government. Land deals, for example, are only supposed to be managed by the federal government. When a land rights action is brought, it's in federal court. The federal government enacts laws and regulations to protect Native American resources because of this trust responsibility. Despite this level of congressional oversight, Native Americans determine whether the items or sites in question are resources they want to protect within the scope of federal laws. ARPA and NAGPRA and the 1992 Historic Preservation Amendments specifically recognize a federal responsibility to consult with tribes on a government-to-government basis. ARPA and NAGPRA also defer to tribes on tribal lands, which means that the federal government has to work with tribal leadership when federal actions impact tribal interests. And an executive order issued in 2000 requires that agencies consult with tribes on policies that have tribal implications. Executive Order 13175, Consultation and Coordination with Indian Tribal Governments, was issued by President Clinton. It requires that federal departments and agencies consult with Indian tribal governments when considering policies that would impact tribal communities, and reiterated the federal government's previously acknowledged commitment to tribal self-government and limited autonomy. Again, Native American nations aren't traditional sovereign nations. They aren't treated the same as other foreign countries. They're what's known as domestic dependent nations, which means that the federal government has a trust responsibility that requires it manages Indian lands, although this hasn't really been of benefit to the tribes. They also provide schools, health care, and other benefits as part of their trust responsibility, or at least they're supposed to. Native American nations have reserved rights for themselves. The term reserved is important. For example, the nations reserved the territory that is now reservation land. That land wasn't given to them. They reserved it. Also, criminal acts committed on reservations by members of that nation are that nation's business and aren't required to be tried in U.S. courts. Any right that a tribe hasn't directly transferred to the government, it keeps for itself. Finally, federal recognition is also important. Federal laws and benefits apply to what are called federally recognized tribes. Federal recognition has been defined in one case as a group of Indians that is recognized as constituting a distinct and historically continuous political entity for at least some governmental purposes. A nation has to have been what the government recognizes as a distinct and historically continuous political entity for many government purposes. There are currently 566 recognized tribes in the U.S., and various groups have had to fight for recognition in order to receive federal benefits. Some have won and others have lost. Again, federal recognition is what qualifies tribes for certain benefits. It's what is required to, in a sense, keep the state government out of tribal business and government. And it's also what was required for the application of certain laws. So remember, keep in the back of your mind these 4 things when you're thinking about Native American issues and as you continue through this module: sovereignty, federal trust responsibility, reserved rights, and federal recognition.